All right, so as I said earlier, actions have 3 stages. You have pleadings, possible interlocutory motions, and then close of pleadings. You are still here. We've been dealing with what's happening here. After this, after close of pleadings, you get pre-trial procedures, which is preparation for trial, includes case management, and it may also in certain instances include certain interlocutory motions. That we'll deal with for tomorrow, most of tomorrow and Wednesday. And then lastly is the trial. We're not yet there. So we're not yet here also, although certain of the interlocutory motions you find here may actually also even only arise after close of pleadings. Okay, good. Just 2 things. The judgment, someone left their cell phone here.
That's fine.
Oh, okay. The judgment of the Judge President that I spoke of earlier, the citation, it's Ongopolo Mining Limited versus Uri's Safari Lodge and others. The citation is 2014. That's the one dealing with prescription and the date. 2014, volume 4. I'm just going to give you the citation that will take you to the name. 2014, volume 4, Namibian Law Reports, page 290, 290, High Court. And you can have particular regard to paragraph 39, where a date in terms of the Prescription Act is dealt with, and actually what the Judge President does in that judgment, which is very useful, is to set out the history of prescription. Okay, so then although I might not be able to tell you the rationale behind the rule, I can tell you that you can look at section 17.1. 17 sub 1, that's a particular section in the Prescription Act, Act 68 of 1969, and that specifically states by statute that the court shall not of its own motion have regard to prescription if it's not raised. So as I said again, I can't tell you why the rule is there, but the legislator in its infinite wisdom decided to enact a provision to that end. All right, so then before we proceed to special case and other related issues, I want to take you just briefly to the works of Herbstein and Van Vinsen, and just principles relating to pleadings in general. Now, what they say, and with reference to a number of authorities, you can have a look at page 558 and onwards of volume 1 of Herbstein and Van Vinsen, if you do have access to this works. It says pleadings serve a number of functions. The most important are: 1, to define the issues upon which the court will be called upon to adjudicate. So that's why I said earlier, if it's not in your pleading, you shouldn't be allowed to rely on it, because the pleadings define what the court at the end of the day should decide and adjudicate upon. It will enable the parties to prepare for trial on the issues as defined. So it takes away the whole trial by ambush, don't know what's expected of me, all of that, because the issues are defined in the pleadings. It serves as a record of the respective claims, counterclaims, admissions and defences, which may be relevant in any other or future litigation between the parties. So you can imagine if the parties have certain issues defined in their pleadings, and then all of a sudden the court is called upon to decide something which is not in the pleadings, and then at a later stage the parties again sue and they say, no, but that was already dealt with there, but it's not in the pleadings there. So it serves as a record also for future. It sets the parameters within which the proceedings will be conducted and evidence admitted or excluded. So of course, a judge would be well with, and should perhaps is a better word, not allow a party to lead evidence on issues that are not on the papers. So if your claim is for contractual damages, then you will be hard-pressed to lead evidence of the defendant's adulterous affair, for instance, just to discredit him with the judge. That's not one of the issues on the papers. It's a very extreme example, but you see where I'm getting at. It's not an issue that's on the papers. Unless, of course, it's probably something that goes to credibility. In that case, you may be able to do certain things, but generally, what you've pleaded is what you are entitled to present in evidence. And then lastly, it also determines the burden of the onus of adducing evidence and the right or the duty to begin. So what's on the pleadings will decide where the onus lies and who has the duty or the onus to begin with the trial, because that differs from case to case. Prepare for trial on the issues as defined. So that really is, in a nutshell, the purpose of pleadings. You can read on on page 566. It says a pleading must allege the facts that are required in order to disclose a cause of action or a defense. A pleading that states conclusions and opinions instead of material facts, or that draws a conclusion without alleging the material facts which, if proved, would warrant that conclusion, is defective. So, material facts. The plaintiff should not, in the particulars of claim, endeavour to anticipate and meet every possible defence to his claim in advance of its being pleaded. It is for the defendant, by raising a defence in their plea, to isolate the particular facts that the plaintiff must prove in order to succeed in the claim. So, essentially, material facts don't need to anticipate what your opponent is going to come and say, what the opponent is going to say, and once the opponent has stated what his or her defense is, then it crystallizes on the pleadings what the issues are. So pleadings, if I have to say what the purpose of pleadings are in one sentence, I'd say it crystallizes the issues. It should be of assistance to the court, it should be of assistance to the parties, because it crystallizes the issues that are in dispute for determination. Okay, so you are welcome to have a look at the works Herbstein and Van Vinsen, the very informative works of what is required of parties in pleadings. Please be mindful, though, that it refers to South African case law, and more importantly, it refers to South African rules, which in certain extents differ from our rules. Be mindful of that, and also keep abreast with developments in our own case law that may change the position as it is in these works. All right, so then let's proceed to Rule 63, which is a special case. You can read through Rule 63. I won't be spending too much time on that. Just know that Rule 63 provides for an instance where parties can provide the court with a written statement of facts as agreed between the parties, and then say to the court, we are not going to present evidence, we agree on the facts. This really is an issue of law for you to determine. So to think of a example, for instance, in a matrimonial cause, the plaintiff and the defendant entered into an agreement, a settlement agreement. The settlement agreement was concluded prior to the institution of divorce proceedings, which in itself isn't prohibited in law, but it also was concluded in an instance where the plaintiff, who was an adulterous party, where the parties agreed that the plaintiff, who was the adulterer, would apply or would seek an order for divorce, which you would know is in our law, given the fault system which is presently still applicable, is a problem. So the question is, the parties agree that the plaintiff is an adulterer, The parties agree that they concluded this agreement, and the parties agree that it was concluded by an adulterous plaintiff and an innocent defendant, and the agreement states that the plaintiff will seek a divorce. Now the question is simply this: is that agreement contra bonis mores? That's the legal question. I'm just using this as an example. So the parties may go on a special case to say to the court, well, decide this issue. Here are the facts, we agree on them, we don't need to lead evidence. You just need to you decide the legal question that arises from that set of facts. So we'll give you a written statement. That's what a special case is. So it eliminates really the need for a trial. And all of these procedures cater for a trial, for preparation, for leading evidence at a trial. But they may say, well, leave all of this for now. We'll give you a statement of the facts as we agree on them, and you can accept those to be the facts. We're not in disagreement. Just decide the legal issue. So there are so many permutations of how this special case can come about, but essentially know that in the very elementary example I've just given you, it's where the parties agree on the facts. They don't want to lead evidence because they agree on what the facts are. They just want the court to make a decision based on those facts. Makes sense? All right. It may also, sorry, yes, just where's the, for instance, I've given you that example, the matrimonial one, for a specific reason. Because you can't seek a divorce by way of motion. You must proceed by way of action, you see. So there will be instances where you proceed by action, or you may not anticipate what your opponent is saying. They may only raise a legal defense. So you don't know whether you foresee a dispute of facts. You proceed by way of action because you feel that's prudent in the circumstances, and then the plea comes along and it really admits all the facts and raises only a defense in law. So for instance, prescription is one of those instances where you may want to proceed on a special case. They may say, I admit everything you're saying, plaintiff, but your claim is prescribed. And the parties disagree, and it's only the prescription, because the defendant may say, well, if it hasn't prescribed, I'm liable. I admit that, but it has prescribed. In which case, you may also want to proceed on a special case and say, all the facts are admitted, these are the facts, decide for yourself. You see what I'm saying? So there are certain instances where this will arise. Separation of issues is also something that falls under Rule 63. This is often where you find that the issues are separated, for instance, special plea before the merits are determined. So let's say there are disputes on the merits, but there are also special pleas which may lead to the end of the matter, and therefore alleviate the need to actually proceed on the merits. That may be decided in advance, and the merits only decided if that's not successful, that special plea. Often merits in quantum, you'll find that. You'll say, the parties say, well, let's not fight about the quantum now, because let's first see whether there is liability. If there is liability, then we may actually be able to settle the quantum, or we'll deal with the quantum at a later stage. Very often, very handy. Now, the general approach is the court doesn't want to approach matters in a piecemeal fashion, but there's always a very real possibility, once liability has been established, that you may want to settle the quantum, or where there's no liability, what's the need of going into a lengthy trial with actuaries, etc., especially when you get to medical negligence claims, etc., where it'll lead to a prolonged trial where you deal with all the damages suffered, bodily injury, loss of income, where you have experts coming in, doctors and actuaries, just dealing with the quantum of your damages. If there's no negligence and there's no cause of action that gives rise to liability for these damages, a separation of issues may be practical to deal only with the merits, and if that's not successful, you wouldn't have had to deal with all the issues relating to quantum. So in certain instances, it's actually advisable to consider a separation of the merits and the quantum, because if you find that there's no case on the merits. There would have been no need to go into the quantum. But on the other side, where you have limited issues relating to quantum, and quantum I'm talking about damages more than anything else, where it really is it's just a panel beater who's going to come and his evidence will take half a day and the other side's evidence will take so you're looking at 2 court days, you're in court anyway, there's probably very little advantage of separating that merits and quantum. So you understand the principles that are weighed up in separating issues and proceeding on a special case. Good. Again, point of law to be determined before evidence is laid. This might also be, as I said, a special plea, locus standi, misjoinder, non-joinder. These are all issues that can also be separated from the main issues. Then we'll proceed to consolidation. I spoke of that briefly earlier. It's Rule 41. When I speak of consolidation in this context, I'm speaking particularly about 2 separate substantive actions standing on their own and then thrown together in the same pot, to be heard together and to be dealt with together in future as one. Now, the main consideration for any consolidation is always the convenience for the court. Convenience to interested parties will be a relevant consideration, but it won't be the main consideration. Consolidation is applied for, it's an interlocutory motion, it's applied for, and it's on notice to all interested parties. It helps if the parties agree that matters must be consolidated, but often there may be disagreement which leads to opposed interlocutory motions in this regard. Once there is consolidation, the 2 actions that have been consolidated, or 3 or 5 or 10 actions that have been consolidated, will then proceed as one action under all those case numbers. So it will be one action and it'll have a number of case numbers dealing with all those cases. That's just practicalities. And the court will make an order as to future conduct of the consolidated action. So if pleadings have not been exchanged, or there's a need for pleadings to be exchanged by one party relating to the other party's action, or whatever the case may be, that, similar to joinder, will lead to an order by the court saying how the parties will conduct themselves in future, how the trial is to proceed, whether the plaintiff is a plaintiff in both actions or separate actions, and it's the same principle. Then the one plaintiff will present its case first, then the other plaintiff will present its case, then the first defendant, so they will be given names, first plaintiff, second plaintiff, or whatever, and the court will direct how they will present their respective cases as the trial then proceeds, or the action proceeds. You ask whether it's the same as joinder. No, it's not the same as joinder. Joinder is just joining a cause of action or joining a party to the proceedings. Consolidation means there are 2 separate actions already instituted and you just want to consolidate them into one action. So it's just that you'll be dealing with them together in future. So you're just putting them all in one pot, so to speak. So it's not the same as joinder, because joinder, you may join a specific party who's not a party to any suit. You may be joining him or her to the proceedings, or you may be citing more than one defendant, or more than one plaintiff might be bringing the action, or you might at the start. Both of these are against a defendant who one evening was inebriated and got into his motor vehicle, and as he pulled away he bumped 5 cars, and amongst them was plaintiff 1's car and plaintiff 2's car, and they don't know each other at all. So this one has instituted action against the defendant, and this one has instituted action against the defendant. It relates to the same issue. It's the same evening, same accident. He bumped both their cars while being inebriated. It's under the influence. I'll be with you in a second. So then he, or they for that matter, may say, well, why don't we just throw all of this into one pot and decide, because if he was inebriated and he's liable, then he's liable to both of them. And they'll both present their cases. It may very well be in a consolidated action, this now becomes the first plaintiff, and this now becomes the second plaintiff in the consolidated action. This remains the defendant. It may very well be that the court says, yes, first plaintiff, he must pay you. Sorry, second plaintiff, you've not been able to prove your case. So it's not to say that if this one is successful, that one will also be. It just means to say that we're going to throw it into one pot because it's easier it's more convenient for the court. Yes, it's similar to joinder in the sense that the right to join for the both of them to sue the defendant in one claim existed at the beginning, but they didn't make use of it because they didn't know each other. They made use of different lawyers, whatever. So that really is the most practical example I can think of to explain to you what consolidation of trials is all about. So it will be convenient to conduct these trials together. It'll probably be the same witnesses, the same people who saw the defendant drinking at the bar, the same people who saw him leaving, same people who saw him getting into the car while he was inebriated, etc., etc. So it's much the same issues. It's convenient for the court. So be wary of class actions. Class actions is not something that each plaintiff must have his or her own case against and make out his or her own case. And of course there the court would consider whether it's convenient because it will be probably a fully fledged trial in respect of each of them. So whether it'll be convenient will be a consideration. So I am not conversant with all the claims against Bill Cosby, but that'll be one of the considerations. Indeed, it may be that it's all against the same defendant, but there's nothing else. So it's all about harassment. But so for instance, say you have a defendant here who's a contractor, building contractor. And he has a number of subcontracts for a number of projects. So this is project 1, and this is project 2, and this is project 3, and this is project, I think my left hand forgets to write what my brain thinks sometimes. Project 4, all right. So he has 4 projects. And for project 1, he has a subcontractor. For project 2, he has 2 subcontractors. For project 3, he has a subcontractor, and for project 4, he has a subcontractor. Okay. Now, it will probably not be convenient and in fact not permissible for this subcontractor, that one, and that one to sue together. Because all they have in common is it's one defendant, but it's completely different issues. He's now in breach of all of these. He's now a very bad contractor who doesn't pay any of his subcontractors. So it'll be very difficult for this subcontractor and this one and that one to now join everything into one pot because it relates to completely different issues. It becomes a logistical nightmare, and it's probably inappropriate to proceed in that fashion. But what can happen is these two can sue together. These two can sue because it's the same project and it's against the same defendant. So it'll be a lot of the same against the same defendant. So it'll be, the Bill Cosby example might probably be the problem you have here. Although it's the same defendant and it relates to harassment, it's whole different. This one might be a minor, so there's other issues. This one might have been rape, whereas this one is only assault, or you see where I'm going. So it might be that, and they'll all have different, probably different evidence, different witnesses, different issues to be determined for quantum, etc., etc. So convenience is an overriding principle in these issues, and it probably won't be convenient where it's too wide apart. All right. Then I think let's talk for a moment about security for costs. Rule 59. It's something that really fits in here. But it's not only there. It can actually also, you can also come across this here, and in rare cases you can even come across this at this stage. Security for costs should be sought as early as possible. It cannot be sought by anyone, and it cannot be sought against anyone. The question you need to ask in terms of Rule 59 doesn't tell you much about the substantive law relating to security for costs. So you need to ask yourself, who is entitled to seek security for costs? So a plaintiff is not entitled. And I'm always surprised. I say this, I've said this many times to the JTC classes, and still I get these notices by a plaintiff who sues a peregrinous defendant who seeks security for costs from the defendant. It's the plaintiff who's dragging the defendant to court, so the plaintiff is not entitled to seek security for costs. It would be a defendant who seeks security for costs, and it would not be any defendant, or it would not be against any plaintiff. So the court will not allow a security for costs to be sought against an insular defendant unless, so it's one, obviously peregrinous, where the plaintiff is a peregrinous. So someone who's not in this, is not domiciled in this jurisdiction. Or two, let's just call it financial dire straits, to make it easy. Unable to pay their debts. So bankrupt or insolvent company sues a defendant, and it's a Namibian company. The defendant is entitled to say, I don't think you can pay your debts. As a result, I want you to set up security for costs. Okay. Where the plaintiff is a peregrinus, you would be entitled to seek security for costs. So it's done by filing a notice in terms of Rule 59. The rule prescribes the form, wherein you say, Mr. Plaintiff, I would like you to set up security for costs in the amount of 200,000 Namibian dollars, and it is because you are a peregrinus or because you are in financial dire straits. You are insolvent. You cannot pay your debts. It should, as I said, it should be sought as soon as possible. There shouldn't be a delay in seeking security for costs. Of course, if there is a delay, it's not an absolute bar, but there's it may be that you will be required to explain why you have delayed seeking security for costs. How should it be sought? It is by means of a notice. So you file a notice. Please be mindful, in incula, the court will not allow an insular to set up security for costs unless he or she is unable to pay their debts, insolvent. And then, of course, a peregrinus defendant is entitled to seek security for costs against a peregrinus plaintiff. The rationale is because the plaintiff is dragging that person to court, therefore there's a security for costs. It shows that the plaintiff is serious in the litigation. How much security should be requested? That depends on the nature of the matter. In some instances, 50,000 Namibian dollars may be sufficient to cater for costs. I can hardly think of such instances these days, but it depends on the matter. It should be the most realistic amount to cater for costs up to the conclusion of the matter. What if the notice is contested? It depends on what's contested, either the liability altogether to set security, alternatively only the amount. When it's only the amount of security that's contested, that's set by the taxing master, and if either party is unhappy with what the taxing master has said, they can take it on review because it's an administrative action. If the liability is contested, that goes to court. It's an interlocutory issue that must be determined by the court. So the court will determine, and there, for instance, a peregrinus can say, well, I'm not a peregrinus because this or that or the other, I own immovable property or whatever it is that he or she wants to raise. Owning immovable property in Namibia, a peregrinus, that's sufficiently unencumbered to deal with security is one of the defenses and considerations a court can take into consideration in determining the liability to set security. But it's not, okay, I own unencumbered security, immovable property in Namibia, so I no longer have to set security. That's not the approach. And then you may be able to prove that you are not in financial dire straits because although your financial statements say that your liabilities exceed your assets, you're actually only commercially insolvent, or you're only whatever, this is the issue, or it's since the financial statements were published, your situation has changed, or whatever it is that a party is able to raise as a defense to its liability to set up security for costs. What if the original amount is no longer sufficient? Well, these days, what has happened is, probably from a practical point of view, is that security is set to cater for up to trial, and then the parties revisit the costs up to then, and then reassess the situation. The moment a party in whose favour security for costs has been granted realizes that their costs now exceed the amount for which security has been set, that party is entitled to again approach the court to increase the amount of security that has been set, or approach the other side, then approach the registrar and or the taxing master to set security. That's security for costs in a nutshell. Any questions? It is an interlocutory proceeding. It does require compliance with Rule 32, but I will deal with that tomorrow when I deal with Rule 32. Do you have a question? Okay, good. Okay, let me just see where we are and where we want to be. Okay, divorce proceedings. So divorce proceedings, you'll also have an issue of summons and exchange of pleadings as in any other action. You'll have the divorce statistics on e-justice. You'll have all the relevant, the Rule 6 reply, etc., etc. I've spoken earlier about the need for a power of attorney these days, and that has been alleviated. Just logistical issues that you can check in the rules. If it's unopposed, if a divorce matter is unopposed, it's set down on second motion court. Now, we, as I've mentioned briefly earlier, we still have what is called the fault system in Namibia, which means that if you are guilty of the breakdown of the marriage, then you are guilty of desertion, and as a result, you're not entitled to seek a divorce. The innocent party would be entitled to seek the divorce. So a party would have to allege in its particulars of claim for a divorce, would be required to allege that the defendant, it's a citation of the parties. Then you'll deal with when and how they were married, when, where, and how. So parties were married to each other on 1 December 2012 at Windhoek, out of community of property, and are still so married. And next, a copy of the ANC if there is one. And then you'll say the parties, or 3 minor children are born of the marriage between the parties, and they are so and so, and they are still minors. Or if they are already majors, you'll say of 2 of whom have since attained the age of majority, or they have all since attained the age of majority, or you'll say that no children were born of the marriage if none was born. Then you'll deal with the issue of desertion. Someone must have deserted the other one. The defendant must have deserted the plaintiff in order to be granted a divorce. It's as simple as that. There's no other way to be granted a divorce. And adultery is also a form of desertion, and it is a cause of action on its own. So a party would say, my husband committed adultery, or my wife committed adultery with so-and-so, and if you name the person, if it's known to you, you'll have to either cite them in the summons if you're also seeking relief against them, although it's questionable whether that relief is of any assistance at the moment still in our law, given the recent judgment by Judge Oitele. And or at least, at the very least, if you name the third party, you'll have to serve the summons on them. And if you're able to prove with evidence aliunde, which means evidence other than from yourself, that your husband or your wife indeed committed adultery. So in one instance, I've actually had the third party testify to having committed adultery with my client's wife. So that's suppose no better than that. And then in certain instances, the defendant actually admits the adultery by way of an affidavit. Or you may have a child, a child who's old enough to testify, who perhaps saw them, or pregnancy is a very good example of adultery. So there are a number of ways in which this evidence from a source other than yourself can permeate and can present itself. And then it will be a cause of action on its own, and when there is proven adultery from a source other than the plaintiff, then the court will grant a final order of divorce immediately. So there will be no restitution order. But we'll deal with restitution orders in a moment. So what will happen is, if it's unopposed, the party who's seeking the divorce will attend second motion court and will lead evidence. Will present its evidence on the divorce, say my husband committed adultery, and this is confirmed by so-and-so, and then you call that person, or you say a child has been born from this adulterous relationship, or whatever it is that how you're going to present the evidence, or my husband has signed an affidavit since admitting the adultery, and then the court will grant a final order of divorce if it's satisfied that a case has been made out. The other causes of action are desertion, which is either actual desertion, malicious desertion, or constructive desertion. Constructive desertion is, for instance, where a spouse abuses another spouse physically and emotionally and financially and whatever means you can think of that you can abuse someone, and that spouse, out of fear for their safety or their dignity or whatever, decides to leave the common bedroom or the common home and says, well, I did leave, so he or she didn't leave me, but it really is constructive desertion because they forced me to leave as a result of their action or conduct, and as a result they are still guilty of desertion. So if you don't allege and prove desertion or constructive desertion, I can hardly see that you will be able to get a divorce unless you rely on adultery. Now, even if you can't make out a case only on adultery, you can still rely on adultery as one of the causes for saying that there was desertion, or constructive desertion at least. You'll have to set out the circumstances as to why you say there was desertion or constructive desertion. So you can say, what I've seen in pleadings and what I've drafted in the past is to say, well, my husband, during the course of the marriage, not my husband, I have a wonderful husband, for the record, my husband or my wife abused during the course of the marriage and with a settled intention to terminate the marital relationship between the parties, abused alcohol excessively, used foul and abusive or aggressive language towards me, physically assaulted me, or the plaintiff. He entered into undue romantic relationship with a third party. He is addicted to pornography. There's so many ways in which a spouse can act that leads to the malicious breakdown of the marriage. You set out those as you would in a particulars of claim material facts. You don't need to say, On 5 January 2007, my husband assaulted me by breaking my jaw. And then the very next morning, he told me that I'm a cow. And the very next, you don't need to say that. You can set it out concisely into these causes, and they all together make up constructive desertion. In addition to that, you may say, and then on the 3rd of January 2017, he left the common bedroom, and 2 months later, on the 3rd of March 2017, he left the common home, and therefore he has, it's been malicious and or constructive desertion. So it's intentional, actual desertion, or constructive desertion, in which desertion he persists. That's the basis upon which a party can seek a divorce in Namibia at present. I understand reform might be coming, but I'm not sure when, how, and where. Then once the court is set, then of course when there's minor children, you'll deal with issues ancillary to the divorce, which would be the minor children, custody and control. Make the allegation that it would be in the children's best interest to be that custody and control be granted to whichever party the plaintiff believes it will be in the best interest, and to deal with the issue of maintenance, spousal maintenance, division of the estate, if any, etc., etc. So those issues are then all dealt with, and then an order is sought. If the court is satisfied, it will give a restitution order, unless, of course, as I said, adultery is proven by a source other than the plaintiff. The court will then grant a restitution order. A restitution order is an order calling upon the defendant, who is now guilty of desertion, to return to the plaintiff and to restore conjugal rights. Conjugal rights meaning marital rights, marital privileges. This is not only from an intimate point of view, it's also your duties as a spouse, returning, changing your behavior, etc., etc. And if a restitution order period has expired, that order is served on the defendant. If the restitution order period has expired, and on the return date there has been no restitution or an offer for restitution, then a final order of divorce is granted. Because divorce proceedings need to be served personally on a defendant, it requires or certain instances you may want to apply for substituted service where you cannot find the defendant. So where the defendant is missing, is not making contact, the plaintiff doesn't know where he or she is, substituted service may be applied for. So affixing the summons to the plaintiff's door or to the defendant's door is not sufficient in divorce proceedings. There must be personal service unless the court has ordered substituted service. All right. Service of a restitution order, same, must be personal service, unless, of course, there's an order for it to be served by way of substituted service. Where there's no return or offer to return to restore conjugal rights, a party files what is called an affidavit of non-return. The plaintiff files that to say, this court issued a restitution order on this date. It was served on the defendant on this date. The defendant has failed to restore or to offer to restore conjugal rights, and as a result, there's been no return, and the plaintiff may move for a final order, and if the court finds that that's in order, the court will then issue a final order. Restoration of conjugal rights can be done in a number of ways. However that's done, whether it's an offer to restore, whether a defendant goes to the plaintiff and says, I want to change my way, I don't want to go through with the marriage, or whether it's a physical act of actually going back and changing his or her behavior, it depends on the circumstances, and the court will take these into account. What will be determined is the fact that a party offers to restore or attempts to restore conjugal rights is not, doesn't mean that the plaintiff is deprived of the divorce action or non-suited. What it simply means is the court will consider the veracity of the desertion and the defendant's actions, and will determine whether there's a bona fide attempt by a defendant to restore conjugal rights. And if there is, then the court will not grant a final order. And if there isn't, then the court will regard that as not being bona fide attempt to restore conjugal rights, and may then still order the final order to be granted. But that depends on the facts of the matter. So that'll be depending on the evidence presented. So what can be done on a return date of a rule nisi for a restitution order? I think you should have a look at Wahikeni versus Wahikeni. The citation is there. That case says essentially the following. It says the issue of desertion is res judicata. That's a special plea, by the way. It's one of the pleas that you can raise to extinguish a claim. The court has already decided on this matter. It can't decide on it again. Court's functus officio. On the issue of desertion, because the court has heard the evidence, the defendant was given an opportunity to defend, he or she didn't, and the court has already made an order. What can be revisited on the return date is the ancillary relief. So a defendant may come and say, well, yes, I've deserted and I'm guilty, but I don't want you to make this order regarding our property rights or the children or maintenance. I want those issues to be revisited. And the court is entitled to revisit those. It's not functus, and those issues are not res judicata. Of course, on the return date also, a defendant can just come to court and say, I want to restore conjugal rights. I haven't done so yet, but I want to do it now. This is why I haven't done so then. And because divorce is a status issue, court will be wary to simply grant a final order of divorce where a party comes to court and says, I want to restore conjugal rights. The court will take that very seriously. Good, so just for a moment, if the res judicata is the issue of desertion, so what a party who wants to revisit that, the desertion issue, will have to apply for rescission or take it on appeal. So you'll have to apply for a rescission or you'll have to take it on appeal. You can only get a final divorce if you can prove adultery. It's the only instance. The court will not grant you a final order of divorce unless it's on adultery. If it does so, in my view, it's doing so incorrectly. You can only obtain, whether you want, or everyone wants a final order of divorce immediately, but you can only get that on where there's adultery, and for obvious reasons. So no, the court will always give the other party a chance to come back and to mend their ways. I must just perhaps mention, please keep in mind all the other principles that apply to actions apply to, and the pleadings in actions also apply to divorce proceedings. So essentially, a defendant can institute a counterclaim when it's opposed, and that can be dealt with. Please also keep in mind that a party may say, well, my husband has deserted me. I did commit adultery. Subsequently, I was driven into the arms of another man because I was left emotionally destitute or whatever the reason is, and therefore I seek condemnation. You'll have to disclose that to court, and you'll have to seek condemnation. If the court doesn't grant you condemnation, you won't be entitled to seek the divorce. So it's very important, if your client has not been an angel, that they say that, and that the court then grants them condemnation. Please also bear in mind that where a party has committed adultery and has told the other party of the adultery, and the other party has been intimate and has been intimate with their partner since then with full knowledge of the adultery, it's considered, he or she is considered to have condoned the adultery. So please keep that in mind also when it comes to matrimonial causes. Yes. When you mention the third party in the particulars of claim, at the very least, you need to serve the summons on the third party. because the third party will have an interest and will therefore need to be served. So the court could and should ask that service on the third party be effected before the matter is proceeded with. Judgment didn't change that. The judgment said that in keeping with the developments, possibly a claim against the third party is probably no longer befitting the times that we're in. Now that must be tested in our Supreme Court, and it must. So that's one view at the moment. I'm not sure what the end of that will be, but that's the position at present. Yes, the court sets time periods. So every motion court that Rule 9 are issued, there are dates, and then I think the minimum is 14 days, if I recall correctly. It's not in the rules; it really is a matter of practice. But 14 days, calendar days, between service of the restitution order and the actual date by which, the final date by which restitution must have taken place. So if there's the court won't easily condone those dates, the court will probably then issue new dates and you have to serve again. Well, as far as I have it, that's the only judgment I know of is the one by Judge Wetele in the High Court. But please bring us a Supreme Court citation. I must have missed that. Well, then, please, I'll check tonight. It may be that I missed that Supreme Court judgment. I'm aware of the one by Wetele in the High Court. Yes, please do. Then we can discuss it tomorrow. I think it doesn't change. You must remember there's a difference between suing someone for an adulterous relationship and serving summons on them where you mention them as the reason for the breakdown of your divorce or your marriage, and the reason because the court says you may have an interest. I want this party to be served with the papers so that they know what's being said about them in this court, because you're using them as a reason to obtain a divorce. So there are two different principles applicable here. I'm not talking about third-party claims at all. I don't know what the position will end up to be, and if there is Supreme Court authority, I don't practice much in divorce law anymore, so I might not have wanted to read the case, but if it's there, then please bring it along. I'd like to see what the Supreme Court has said on that issue, but I haven't dealt with any third-party actions in divorce for quite some time, so it'll be interesting to see, so please bring. There's actually a judgment to that. I'm not sure whether it was reported, but the current acting Supreme Court Judge, Judge Smuts, Judge Frank, gave a judgment to that effect, because that is essentially, it must have been about 7 or 8 years back, maybe even longer, where it was exactly this instance. The one party who was the guilty party wanted a divorce, and the innocent party said, I don't want you to divorce you, and he couldn't give an order for divorce. Okay, I can see where you're going with that, but it doesn't appear to be in keeping with our law on divorce, because if there's an offer for restoration of conjugal rights, the court must establish whether that's a bona fide offer, where a plaintiff doesn't want to accept it and says, I'm not going to accept it because it's not bona fide. The only reason you're coming back to me is you don't want to pay for the children. You can never forfeit your right to claim maintenance for the children. That the party can never forfeit. That would be unconstitutional. But it's spousal maintenance. I'll have to have a look at the judgment, because it doesn't ring a bell to me, and it doesn't seem correct to me, because, and I mean, there may be other considerations that may have been relevant in that matter, so I can't say off the cuff. If you can maybe find that judgment and send it to me, I'd love to read it and just have a look. I suppose it's not reported, because I can't recall having read something like that. Could be, but let's because essentially, if there's an order or an offer to restore conjugal rights or an attempt to restore conjugal rights, what the court will do is not give the final order of divorce. If the plaintiff doesn't want to accept the offer or the attempt to restore conjugal rights, then the court will say, let's consider whether this is actually bona fide. And if it is, the court has said, go back to your wife or go back to your husband. This person has complied. The court then cannot grant the order unless it finds that the offer or attempt to restore conjugal rights is not bona fide. That's essentially, it differs substantially from South Africa. where you can simply go and say, there's a Divorce Act, and you say, there's irretrievable breakdown of the marriage, and I no longer want to be married to this person, which is probably in keeping with the times. And I'm not by this saying that I'm in favor or not in favor of divorce. I'm luckily still happily married, but I'm just saying that times have changed since then, and it is an excessive burden, I suppose, on the courts, the whole restitution issue and determining, but you'll be surprised how few divorces are actually fought because the parties still want to be together. They actually just fought over money at the end of the day. It fits into opposed divorces, so when a divorce is opposed, then it's sent for mediation. Court-connected mediation or private mediation if the parties agree to that and agree to pay for that. And then it proceeds to trial, and then similarly, a court will only grant the restitution order. It won't grant a final order on conclusion of a trial. It'll still be a restitution order. Once you're able to prove what you've set out to prove, the court will grant only a final order if you're able to prove adultery. The court will only grant, in all other circumstances, a restitution order, even though you've gone through a fully fledged trial. The restitution period is something that's by way of order of court, so it's like a rule nisi. I think it's roughly about 6 weeks from the restitution order being granted until you being back in court for the final order. Roughly about 6 weeks. I'm not. Don't quote me on 6 to 8 weeks. And the court has a certain period by when you have to serve. And it's if I recall correctly, I haven't been in second motion for years, but if I recall correctly, I'll just make sure tonight with a colleague, it's 14 days from the day on which service of the restitution order was made on the defendant until the time expires, at least 14 days, until the time for him or her to return expires. The fact remains that in our present divorce law as it is, final orders of divorce can only be granted either after a non-return following a restitution period, or where a offer or attempt to restore conjugal rights has not been bona fide, or where there is proven adultery. Those are the only instances. So I'm not saying it doesn't happen otherwise, I'm just saying it shouldn't happen otherwise, because that's not our law at present. That's not the way in which, but it may develop, and at the end of the day, the Supreme Court will have the final say. This is not governed by statute. That's just the law as it has been and been practiced in this dispensation throughout. In an instance where there's severe abuse, and restoration would probably lead to more abuse, that would probably mean that an offer to restore would not be bona fide. The simple issue I think comes to mind immediately for me is that you are depriving a defendant in a status matter from a procedural right and a substantive right that he or she is entitled to, that is to change my ways and go back to my wife or my husband. You see. So whether you can do that, a party is entitled to accept that once a divorce is sought on desertion, whether malicious or constructive desertion, when the matter is called in court, he or she, the defendant's spouse, is probably entitled procedurally and substantively to accept that the best that can happen there is to issue a restitution order, and then I will be granted an opportunity, and they may have the intention to restore conjugal rights, to change their ways, to stop drinking, to do whatever is required to save the marriage. And then they are deprived, and it's a status matter, so it's a very important matter. So whether that's correct is probably questionable. With all due respect to whomever wrote the judgment, I'm not sure that that's entirely correct in the circumstances, and also giving effect to the procedural, substantive and constitutional rights of the defendant, who's entitled to accept that he or she, your counter argument may be you had your chance, it's been years of abuse, etc., but that is the law as it's been practiced in this dispensation for years and years. that develops and RCRs are now replaced by final orders in extreme circumstances, you can try. There's nothing prohibiting, I suppose, a party to try and do that. Whether that will be allowed in the circumstances and weighing up the rights of all the parties, considering especially that one of the parties are unrepresented there in a status matter, is an important consideration, most certainly. That's just my bit of information. All right, I wanted to do a short comfort break and then proceed with another aspect, but I didn't want to keep you for much longer than after 4:30, 4:45. So I think what we should focus on now, if there are more questions, I just want to see what the next, because that really takes care of divorce proceedings. I want to proceed to absolution from the instance, but absolution from the instance and close of pleadings is going to take some time. So I don't want to start with that now and then leave it over for tomorrow. Perhaps I can just ask you, going forward for tomorrow, that you have a look at the principles relating to absolution of the instance, so that it's not entirely foreign to you when we come in tomorrow. I will be dealing with, I'll just finish off the close of pleadings and absolution from the instance tomorrow, which falls in with what we're trying to do. Then I'll deal with discovery, expert evidence, requests for trial particulars, witness statements, indexing and pagination, practice directives, managing your court diary, delivery of judgment, and cost awards. I'll do that tomorrow up to lunch. And then after lunch, we'll do judicial case management, which will continue on Wednesday morning. And then I'll deal with interlocutory matters from after the tea break until we adjourn. I also have a list of questions that I thought prudent that you have a look at. I don't know whether you have this, but if not, I'll just mention them. You must know the process of fact-finding in action proceedings, and you are referred to the Stellenbosch Farmers Winery Group Limited and another versus Martel, and another, that's a Supreme Court of Appeal judgment in South Africa, and then you versus Minister of Education. That's a Namibian case. The citation is 2006, Volume 1, Namibian Law Reports, page 168. And the Stellenbosch Farmers citation is 2003, Volume 1, South African Law Reports, page 11, Supreme Court of Appeal, and you'll find that at paragraph 5. Then I just want you to consider for discussion, we'll discuss that tomorrow. Do you know about the case management in the High Court of Namibia? How has the role of the judge changed? What are the new ethos of civil litigation in the High Court? And what is a case plan? So these things we'll discuss just for clarity tomorrow. The recusal you'll not be doing with me, but the test when faced with an application for absolution from the instance at the end of the plaintiff's case. The function of striking out in civil proceedings. The principles relating to summary judgment and default judgment. We've dealt with default judgment, so we may have some questions tomorrow. The principles relating to an exception, which is an interlocutory matter that I'll deal with for most of Wednesday. Make sure you know the order of pleadings in action proceedings, as I've set them out earlier. The role of pleadings in civil litigation, I dealt with that earlier. Make sure that you read up on that. The grounds of divorce, what these are, how they permeate in different matters. How does a litigant seek interim relief in a divorce action? Inherent jurisdiction of the High Court, what inherent jurisdiction of the High Court means and how that's different from the Magistrates Court. What is meant by the expression the High Court is the upper guardian of all minor children? Do you know what the role of discovery is in civil proceedings? And distinguish between discovery in civil proceedings and discovery in motion proceedings. Rules and case law relating to amendment of pleadings, very important, and the new case law on amendments. What is a cause of action? What is a third-party procedure? What is joinder and misjoinder? What do you understand by taxation of costs? Distinguish between party and party costs and attorney-client costs. And then I won't deal with admiralty matters, so you can do that. You probably do that with one of the other lecturers. All right, so let's just conclude this part of what we've done today. I've said to you, we are at stage 1, which is pleadings, interlocutory motions, and close of pleadings. And we've dealt with divorce proceedings and matrimonial causes. Do you have any final questions on any of the issues that we've dealt with? No, well, if there's a counterclaim, then for the counterclaim, a plaintiff in a counterclaim, who is the defendant in the counterclaim, would be entitled to seek security for costs. It won't be against an insular plaintiff unless he or she or it is unable to pay their debts or in financial dire straits. So you'll find it under matrimonial causes and matters, part 9 of the High Court rules, and you'll find it under Rule 90. So it'll be a Rule 90 application. It's the same as the old Rule 43 application. So that's for interim relief. It's an application brought. It's really a special kind of application. It's brought on motion, and you, for instance, would, if you overburden the papers in that instance, then you may actually find yourself in a difficult position. There's a lot of case law on that. So it must be as simple as possible, as concise as possible, and it relates to interim relief relating to maintenance, spousal maintenance, maintenance for the minor children, interim custody and control of the minor children, contribution towards legal costs. These issues are dealt with pending the finalization of an opposed divorce. So it really is a mechanism to easily and without too much cost and hassle assist a party in obtaining interim relief from a spouse or against a spouse pending the finalization of an opposed divorce. So it's Rule 90 at the moment. There's definitely a case in the Constitutional Court in South Africa, as far as I'm aware. Whether our Constitutional Court has decided on that, I'm not sure, but you're welcome to. It's not something in my view, arresting someone for debt is unconstitutional, and therefore I wouldn't advise. Well, technically, I suppose yes. Well, I mean, if it's been declared unconstitutional in this jurisdiction by the court, then it shouldn't be. I'm not aware of a judgment to that effect, but it may be that I've missed that. So I'll check tonight to see if. Yes, but it's arresting a debtor is one thing. That's unconstitutional. Suspectus de fuga is where someone is fleeing the country and you want to avoid them fleeing the country to not pay their debts. So it's and these things usually lead to a lot of discussion in the corridors, at least at the Society of Advocates. So it may, I mean, I had a couple of babies. It may be that I missed something, but as far as I'm aware, there's not yet dealing with suspectus de fuga. But what I think we should do is all of us just check tonight. I mean, it's a Google search, see if we can find something, and we can discuss it tomorrow, and it'll bring us all abreast about suspectus de fuga. I didn't prepare on that specifically now because it's not something that I'm lecturing on, but I'm more than happy to have a look and we can discuss that tomorrow. But as far as I'm aware, South Africa, that has been declared unconstitutional, and insofar as it may technically still be allowed in Namibia, I'm fairly certain. In the old rules, you could actually just, I'm not sure whether it's, I'll check, but in terms of the old rules, you could actually just apply, you could have applied to the registrar for an order to attach someone. So that's quite alarming, but that situation has of course changed. All right, so any other questions? We'll all talk about suspectus de fuga first thing tomorrow morning, and then we'll proceed with absolution of the instance close of pleadings, and then we'll go over to those pre-trial procedures and case management. So we'll be we'll be migrating from here to here tomorrow. We'll be spending all of tomorrow here, and then the day after still here, and we'll be dealing with interlocutory motions. I won't be dealing with you with trial. I see later in the program you have presenters who will be dealing with onus of proof and trial and how you conduct the trial, and that's not I'm dealing with civil procedure up to trial. So I won't be talking a lot about this. It is that here or there it falls into what I'm saying, but generally my focus is on those two areas. All right. Thank you very much. It's been a long day. I think we all have heard a lot. So think about it this evening. If something puzzles you or you want me to address something tomorrow morning, I'll be more than happy to do that. If you want to send me a WhatsApp and ask me something, and if I'm available, I'll certainly try and deal with it. Otherwise, I'll make a note and we can discuss it tomorrow morning. Good. Enjoy your evening. See you tomorrow at 8:30. Thank you.